How do we find the dispute resolution mechanism? Look at the dispute resolution clause of the contract. Bawat kontrata usually would have a dispute resolution clause. So the dispute resolution clause determines the mode of settling disputes between the parties. I'll show you later samples of the dispute resolution clauses of contracts. If there is no dispute resolution clause, disputes shall be resolved through courts or the institution mandated by law. Kasi wala kayong in-indicate eh. So you go to the default, which is litigation. Or, kung merong quasi-judicial body, yung quasi-judicial body, yung mag-resolve ng dispute ninyo. I just want also to share with you the usual checklist. Kasi alam ko na we already in ADR now, but I also want you to, you might be asked by your farmer beneficiaries to help them draft an ADR clause. So ano yung dapat na nakalagay sa ADR clause natin? The clause might cover all disputes that may arise or only certain types. Clear dapat yon. Tanungin nyo yung kliyente ninyo. Do you want this particular mode, yung pinili nyo, mediation, negotiation, arbitration, to cover all disputes arising from these contracts or only certain disputes? Gusto nyo, for example, yung price, for example. Kasi price is a very technical. Or merong questions on operations, farm management. So, pwede yung mga ganong questions because they are highly technical. You don't expect the court to be able to have the necessary competence to resolve disputes. Pwede yan na ilagay as to be resolved by an arbitral body. And the rest, like concepts like, for example, yung delay, for example, which are more capable yung court to determine, pwede yung ilagay as litigation. Or you could just have the entire contract to be resolved by arbitration or by mediation or negotiation. With respect to arbitration clause, ang problema kasi with contracts, usually when a dispute arises, it's not just between the parties. It could involve subcontractors, suppliers, or other parties who have not been part of the original contract. To be fully effective, entry of judgment language in domestic cases is important. You have to put, for example, that any, especially for arbitration, that any judgment award, yun pala yung term dyan pag arbitration, award, is actually binding on the parties. So, maganda yan, ilagay natin explicitly. Minsan, we have to indicate then kung, kasi hindi since it's highly consensual, walang established na procedure, ilagay natin doon, is that appealable or subject to motion for reconsideration, for example? Can you question it? So, usually, nakalagay dyan, kung ano yung nilabas ng arbitral tribunal or yung ad hoc arbitration body, final na yon and binding over the parties. Walang appeal, walang reconsideration, yun na yun. Pwede nating i-indicate yan sa ating agreement. It is normally a good idea to state whether a panel of 1 or 3 arbitrators to be selected and to include the place where the arbitration will occur. Dapat hindi lang tayo, we should not end indicated that all disputes arising from this contract shall be resolved through arbitration. Ang labo nun, hindi pwede yun. Malaking problema yan. Kailangan yung i-indicate, una, kung meron bang arbitral institution na hahawak sa arbitration na to. Or, kung wala man, there should be a procedure for the election of the arbitrators. Usually, yung yung ginagawa ng partido, if it's a relatively simple case, kontrata, isa lang. Meron kang sole arbitrator. Tapos, kung more complex cases, and for example, based on the relationship of parties, they don't trust each other, it's better to have 3. Huwag kayo maglagay ng even. Paano, di ba? Maging problema yan. Kasi sila yung magbo-vote eh. So if you have 4, paano yung majority 2-2, for example, di ba? So, it's better to choose odd numbers. 3, 1, 5. Depende sa complexity. Take note then na the more you have, the more expensive the arbitration will be. Kasi mahal yan. I also would like to point out that it's really very, very, very important to indicate the place of the arbitration. Ito yung tawag nila the seat of arbitration. I know, technical to, pero yung seat of arbitration kasi, yun yung law, yung lugar, yung kanyang batas ng lugar na yan, yung magagovern sa proceedings na yan. So if you have questions on how the rules of procedure will be interpreted, if you can get reliefs, provisional remedies from the court, pwede ka bang kumuha ng temporary restraining order pag hindi sununod yung order ng court or nag-violate siya ng confidentiality agreement. Mga ganong technicalities. It will be the seat of arbitration which will give you the answer. So dapat clear yan. Examples, agreement ninyo, the Philippines or Manila shall be the seat of arbitration. Ibig sabihin yan, it will be Philippine law, which will determine kung ano yung ibig sabihin ng arbitration rules of procedure niya, yung agreement ninyo. It will be in light of that law, which the agreement will be interpreted, determine the scope, the powers, and the effects of that arbitration proceedings. In case na hindi provide ng parties. If the contract includes a general choice of law clause, it may govern the arbitration proceeding. The consequences should also be considered. Minsan, sa mga, especially for cross-border contracts, yung between, example, like exports, yung mga shipping, yung makukuha ka ng services, ito yung mga mas complicated. It will involve a foreign party. Important na clear kung ano yung governing law. Do not assume na kasi yung kliyente ninyo is a Filipino, yung place of performance ay Philippines, ibig sabihin dito ginagawa yung kontrata like a banana production, dito siya ginagawa. Automatically, it's Philippine law. Not always the case. Tingnan niyo yung kontrata kung ano yung nakalagay. It could be the laws of the other party like China, Iran, even English law, could be the governing law. And whatever governing law indicated in that contract, that governing law will determine the interpretation of the agreement. Important yan, yung rights and obligation of the parties. So consideration should be given for large, complex commercial disputes, but the parties are free to customize. Yan yung important kasi it's consent-based So they're free to customize whatever procedure na nakalagay. They're not bound. Kaya pag sample sa negotiation, sinabi sa inyo, gusto namin rules ng ICC, International Chamber of Commerce, na mag-govern. It doesn't mean that yun na yung yun yung kaagad i-adapt nyo. You're free to customize the procedures based kung ano yung gusto nyong mapag-usapan. It will be more convenient for the parties. So ito yung mga dispute resolution clauses na gustong ko pakita. So litigation usually, ganito, any dispute arising or connected or in relation to this agreement shall be resolved through litigation in the courts of Manila to the exclusion of other courts. So ibig sabihin, pag may dispute sa kontrata na to, saan natin ipa-file yung case? Sa Manila. Ito naman is a clause indicating that negotiation is the mode of dispute resolution. Ano nakalagay? In the event of any dispute, claim, question, or disagreement arising from or relating to this agreement or breach thereof, the parties hereto shall use their best efforts to settle the dispute. Best efforts. To this effect, they shall consult and negotiate with each other in good faith, and recognizing their mutual interest, attempt to reach a just and equitable solution satisfactory to both parties. If they do not reach any solution or such solution within a period of 60 days, then upon notice by either party to the other, all disputes, blah, 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 shall be finally settled by arbitration administered by the Philippine Dispute Resolution Center, Inc., in accordance with the provisions of its arbitration rules. So una, within 60 days, they have to resolve their dispute first through negotiation, and then kung hindi nila ma-resolve yung kanilang dispute through discussion in good faith, saan sila pupunta? Saan? PDRCI, sa Philippine Dispute Resolution Center. At ano yung mode? Arbitration. Okay? How about mediation? If a dispute arises out of or relates to this contract or the breach thereof, and if the dispute cannot be settled through negotiation, the parties agree first to try in good faith to settle the dispute by mediation, administered by the Philippine Mediation Center, under its mediation procedures before resorting to arbitration, litigation, or some other dispute resolution procedure. So, una, ano yung gagawin nila? Negotiate. Pag hindi sila nag-settle through negotiation, anong gagawin next? Mediation. Saan? Philippine Mediation Center. Okay? Ano yung rules na gagamitin nila? Yung mediation rules ng Philippine Mediation Center. Okay. Tapos, pag hindi pa rin sila na-resolve ng Philippine Mediation Center, saan sila pupunta? Possible. Arbitration, litigation, or some other dispute. Basta malabo actually ito na clause. Pero this is a sample, yung mediation clause. Resolution through arbitration. The parties shall attempt to resolve any disputes arising through negotiation. Usually, yan yung una. If the matter is not resolved by negotiation within 30 days of receipt of a written invitation to negotiate, the parties will attempt to resolve the disputes in good faith through an alternative dispute resolution procedure or in default of agreement through ADR procedure as recommended to the parties by the President, Deputy President, and time of the Chartered Institute of Arbitrators. So ito, meron silang in-indicate na institution. At ano yon? Chartered Institute of Arbitrators. So yung rules of procedure ng Chartered Institute of Arbitrators, yun yung magagovern on how they will proceed with their arbitration. So yeah, usually complicated yan eh. Example dito, so naka-indicate din, the seat of arbitration shall be the Philippines. The arbitration shall be governed by the Alternative Dispute Resolution Act of 2004 and arbitration rules as agreed between the parties. And then there's on how they would get the arbitrator. Okay? So meron procedure dyan. And then take note of the last clause. Ano nakalagay? Nothing in this clause shall be construed as prohibiting a party or its affiliate from applying to a court for interim injunctive relief. So, yung mangyayari dyan, kahit naka-indicate na sa inyong kontrata ay arbitration, it doesn't stop the party from seeking reliefs that could still be granted by courts. Okay? The courts are empowered to issue certain types of reliefs under the ADR Act of 2004. Ano to yung mga reliefs na to? TRO. For example, yung mga discovery procedures na nakalagay doon, pwede yung apply sa korte to force them to reveal the information na, but it's, madami yan, nasa ADR Act of 2004, kung gusto niyo yung makita. So the courts, even though they have been excluded from the resolution of disputes, could still participate with respect to certain matters in the disputes. Kasi yung arbitral body, wala naman talagang capacity yan to enforce in itself. Example, private individuals, di ba, yung kinuha nyo as arbitrators, alangan naman sila yung pupunta doon para kunin yung mga bagay na you want to get from the other parties. Usually, the mode of enforcing it is yung voluntary through the volition of the other party. However, kung hindi sila talaga susunod, then ano yung gagawin mo? Go to court. Di ba? And then ask the court to enforce the judgment issued, or the award issued by the arbitral body. Usually, under the ADR Act of 2004 and in a case decided by the Supreme Court, sabi niya, pag yung chosen mode nyo of dispute resolution is arbitration, the courts actually are divested of jurisdiction. That's the Korea Technologies case. So, very clear na ngayon. Before, it was a confusing ruling. But right now, kung in-indicate nyo ay arbitration, yung means of resolving the dispute with respect to the issues indicated in the contract could only be resolved through arbitration. Take note also of the condition precedents. Okay? Bakit ko siya point out dito? Kasi usually sa kontrata, may mga steps yan before you could resort to arbitration or litigation. Tingnan nyo yan. Kasi ano mangyayari pag hindi nyo sinunod? The filing of the complaint or notice of arbitration is premature and therefore may be dismissed. Yun yung result niyan. So sayang yung pera na ginugol ng parties nyo kasi premature, hindi nyo sinunod. Ano ba yung mga condition precedents na pwedeng ilagay dyan? Nakita nyo kanina, di ba? Bago daw sila mag-file ng arbitration, ano kailangan nilang gawin? Negotiate for 30 days. So, pag hindi kayo nag-negotiate ng 30 days, sabihin ng, tapos nag-file na kayo ng notice of arbitration, ang sasabihin ng arbitral body, premature to. I-dismiss namin to. Kasi hindi nyo sinunod yung nakalagay sa kontrata na kailangan mag-negotiate muna kayo. Okay? So, kaya very important yung condition precedents. Tingnan nyo din yan. Important concept, especially in rescission of contracts, is substantial breach. Hindi lahat ng breach ng kontrata ay pwede nyong pumunta kayo kaagad sa korte or pwede rin sa arbitration, ipaparesidyo kaagad. Kinakailangan, the rule, like in the Philippines, it is a settled principle of law that rescission will not be permitted for slight or casual breach of the contract, but only for such breaches as are so substantial and fundamental as to defeat the object of the parties in making the agreement. Bakit? Kasi ang kontrata is the law between the parties. Important yan. Contracts are to be observed, are to be complied in good faith. Diba? So, kinakailangan i-balance yan ng korte or ng arbitral body na yung pag humihingi ka ng relief of rescission, kinakailangan that breach involved should be substantial and fundamental. What is substantial and what is fundamental? May mga test po dyan depende on the issues involved, on the obligations involved. Depende sa issues talaga yan Pero basta yung importante, it has something to do with the main reason for the contract. Parang yung main obligations of the contract. It has to be contrary to the main obligations in that contract. In cross-border disputes, take note of these two provisions. Choice of law and choice of forum. Yung choice of law, yan yung mag-indicate ng governing law. And then yung choice of forum naman, yan yung mag-i-indicate kung saan nyo ipa-file yung, example, kung arbitration siya or litigation siya. The parties are free to stipulate, so to indicate kung saan nila ipa-file yung kanilang dispute. Other considerations. Authority to engage in dispute resolution. Bakit? Usually, pag isa pa sa negotiation or sa mediation, pag wala kang authority, then salita-salita lang yan. It will not bind the parties. Especially if the parties involved are juridical entities, cooperatives, corporations, associations, partnerships. Only one person lang yung nagsasalita dyan, but it will bind the entire institution, entity. So, kinakailangan niya ng proof of authority. Cost, of course. Kailangan mo i-consider yan. Political and social consideration, support of the members. We'll explore that later when we discuss negotiation. Expertise, especially in disputes involving technical matters. Yung pinakauna po na arbitration na hinawakan ko before involves oil wells na sa Palawan. Wala akong kaalam-alam kung paano kinukuha yung oil from the well, and then kung basta may mga discussions sila about the amount of oil per hour, tapos yung gallon, tapos yung technology involved. It's a very technical dispute. So, yung ginamit namin doon sa arbitration na yon are experts sa oil production. So, important yun. For example, in banana later on, or in rubber, or in particular agricultural industries, take into consideration nyo yung expertise na kakailanganin nyo. Ang cost actually is borne by both parties pag ADR. Okay? Ano yung sharing? It could be by agreement. Usually 50-50. When di ba may nakalagay doon na resolution of dispute through say arbitration, tapos subject to the rules of this particular arbitral body. So nandun sa rules of procedure ng arbitral body yung papaano yung distribution ng cost. May formula yan sila usually. Okay? Kaya important na indicate nyo, for example, kung ano yung arbitral body na hawak sa conflict na to. Para hindi mahirap kaaway-away pa kayo kung paano i-distribute yung cost. Unlike kasi sa litigation, di ba, yung cost kasi, sino mag-bore ng cost? Yung nag-file ng complaint, di ba? Siya yung magbabayad ng filing fees. Dito, not necessarily. Kasi it's consensual. So, based sa kung ano na pag-usapan ng mga parties. So, financial resources, especially for protracted dispute resolution. Important question that we should ask ourselves. Does it address the client's needs? Yung mode of dispute resolution natin. So, kahit na nakalagay actually sa kontrata ay ito yung arbitration, it doesn't stop us from exploring other means of dispute resolution. Okay? Kahit nakalagay dyan, litigation, it doesn't stop us to explore negotiation. It doesn't stop us to explore mediation. Kasi ang important is not really to strictly follow the contract. We are not actually imprisoned by the contract. The contract is supposed to serve the intents, the purposes of the parties. It should not be the other way around. That should dictate the parties on how they will go with their dispute, resolve their dispute. As long as, well, contracts kasi siya, so as long as the other party agrees and you're able to convince the party na we will resolve it through negotiation first, maganda, you don't have to go to arbitration in Paris, for example. Yun nga lang, hindi ka makakapunta ng France, di ba? Pero, nonetheless, less cost yun sa kliyente mo. Yung important consideration. So, kahit na nakalagay dyan, arbitration, clear na indicate nyo sabihin nyo sa inyong kliyente, arbitration po yung mode of dispute resolution natin dito. Pero hindi kinakailangan na hindi natin explore muna yung negotiation. Okay? So, another important is identify the interests of both parties, anticipate the allegation to be raised by the counterparty. And then an important question, can we implement the award? Example, nanalo tayo. Yung partido nyo ay actually taga-Ecuador. Patay, di ba? Oo, wala naman sila ditong assets na pwede nyong kunin, pambayad sa utang nila. Kasi nag-import sila ng bananas from your clients. Di ba? So, you need to know, can I implement the award? Ano yung kinakailangan ko para i-implement yung award na to? You have to discuss this to your client. You have to discuss this. Hindi lang, dito, mananalo tayo, maganda yung kaso natin. Hindi doon nagtatapos yung problema ninyo. Eventually, the goal of your client is to be able to get the proper remedy to effectively restore him prior to the dispute. Yun talaga yung kanyang goal. Hindi yung manalo sa award. Anuhin ko yung magandang award yan kung hindi ko naman makukuha yung aking 10 milyon o 1 bilyon, di ba? Wala yan. It means nothing. It's just a piece of paper. Okay? So, kailangan nyo nang erase yan sa client.